with the technical details to start. So this second session, it is going to be online, as you see on the screen, but we have two speakers. So one of them is Ralf Bendrath, and he is an advisor on civil liberties, justice, and home affairs. And then we have Thomas Lohninger, and he's from Epicenter Works. And they will be telling us all about the EU's reform agenda, specifically this legislation that is called Digital Simplification Package. So, yes, the speakers online, if you're ready.
Great, hello and welcome. We are both sorry that we couldn't be with you in person, but nevertheless it's great to be at this amazing event, and we want to talk you through the current reform agenda of the European Union. Ralf and I are both working on this. We have different roles. I'm executive director of the Digital Rights NGO Epicenter Works, and we've been involved with EU policies over the past 16 years. And Ralf will introduce himself.
Yes, I work for the Greens in the European Parliament, and back in the day, more than 10 years ago, I worked for the chief negotiator on the General Data Protection Regulation. The picture here you see is my laptop on the last day of the negotiations. The text on the laptop screen is the GDPR. So now the Commission is proposing to change and weaken the General Data Protection Regulation. So for me, this is personal.
And we want to walk you through what the hell is going on, and we do not expect anyone to know something about Europe or Brussels or digital rights. This should really be inclusive, and at the end we also want to have time for your questions. But what even is an omnibus? Because omnibus is a word you hear all the time here. And of course it comes from real buses. It is a form of carriage, and a horse carriage or automobile that carries many people. So you mix things into one container in a way and transport it. But in lawmaking, of course, it refers to same principle, but a package of different legislations or laws that concern unrelated topics, but that are voted on as block, and thereby can basically a drive-by shooting of many other legislations all at once.
So how did we get here? This kind of started in 2023 when the Commission President Ursula von der Leyen asked Mario Draghi, this other guy here, former chief of the European Central Bank, to write a report on the future of European competitiveness, because you could argue we are kind of lagging behind the US in terms of artificial intelligence, behind China and on electric cars and so on. So how could we improve European competitiveness, make European companies more competitive on the global market again? Fair question, you could argue, and he published his report and handed it over to the Commission in September 2024. And this then was taken by the Commission to kick off a whole reform agenda.
Yeah, and we see here a range of different laws that are sadly still in German, but you basically can see, might it be the due diligence issues or issues around food safety, defense, chemicals, automobiles, environment. It's really a broad simplification agenda, and the yellow highlighted parts are the digital ones that we're going to talk about. And Ralf was in the negotiations on most of them, if not all of them. And so we have the small mid-size caps that's already concluded, the AI Act that's already concluded, the data one, that's going to be a major issue for us. And then there's also the Digital Networks Act that I'm going to talk about, which concerns net neutrality and is also an attempt to deregulate. And lastly, there's also a non-specified digital fitness check that might also lead to further changes to other laws, but we do not have the details about that yet. And from a civil society perspective, it is extremely interesting to see the broad range of stakeholders that are engaging here. This is not just the usual suspects like the Chaos Computer Clubs and EDRIs and EFFs. This is really going from the Latvian police force to the Beekeeper Association of Europe. It includes most, if not all, environmental organizations and unions, but also fair trade groups. And so what we are faced with is really an unprecedented level of solidarity. That is also a quite hopeful message, because we are all faced with the same agenda and the same stupid logic to take away all of the civil liberties that we have gained in the past 10 years. Underlying all of this, of course, is the new right-wing majority in the European Parliament that we have since the election 2024.
Yeah, and you can really see how they are more and more radicalizing. It started again with competitiveness, but now with the Omnibus agenda has turned into simplification, quote unquote, and now they're openly speaking about deregulation. And we have a video here, but unfortunately, I understand you don't hear the sound, so we will have to skip this. This is Ursula von der Leyen at a conference 1 year after the Draghi report, where she basically says, we all agree we need simplification, we need deregulation. But it's not just Ursula von der Leyen. Next slide. This is Svenja Hahn, a German liberal member of the European Parliament. This is 1 week before the digital omnibus proposal came out last November, an op-ed in the German Frankfurter Allgemeine Zeitung. I mean, you see the title. This is the mindset.
And you could then think, is this actually supported by the European population? I think we can all agree that we have problems with big tech. I think nobody is doubting that. And many also would see the European Union in the leading role to come up with solutions for these multilateral problems. And we are all aware that Donald Trump doesn't like regulating big tech because that's where a lot of his money comes from. And so if you then put these two things in a poll, you see that actually 2/3 of the population in the 3 largest countries in Europe are still in favor of regulating big tech, even if it would deteriorate the relationships with a Trump administration. So I would argue there's no real backing for what the Commission is doing here, even if you factor in global circumstances. And now about the impact of the reform.
Yes, what's happening actually? What are they proposing in terms of substance on the digital front? As Thomas mentioned, there was already the so-called fourth omnibus on small mid-caps. This is small companies that are bigger than SMEs, but not too big. Mid-cap stands for small companies with medium market capitalization. There, they already changed the GDPR by deleting the obligation to keep a record of your processing activities, basically to know what you're doing with personal data when you're a small mid-cap. At least we managed some damage control here, and still now, if you already have an obligation under the GDPR to appoint a data protection officer or to do a data protection impact assessment because your data processing is high risk, then you still need to keep this record. So that's already done, more or less. We will vote it in committee level next week. But the big reform is now the so-called seventh omnibus that was presented on 19th November last year, which consists of 2 omnibus laws. One is on the Artificial Intelligence Act. We'll come to that later, but that's also maybe more or less already done. And the other one is the big data or digital omnibus, which is amending a whole bunch of laws, the General Data Protection Regulation, the e-privacy directive, the Open Data Directive, the Platform to Business Regulation, the Data Act, the Data Governance Act, and the Network and Information Security Directive 2, I think. So some people in Brussels already call it the Big Beautiful Data Bill. And here they are really going, next slide, at the core of data protection. They're not just deleting some rules or making some rules simpler or maybe deleting some obligations for small companies and so on. They're going really at the core, which is the definition of personal data. Because if you suddenly say this data is not personal data anymore, then the whole data protection law doesn't apply and you're completely out. You can do with the data whatever you want, sell it to China, publish it, remix it, whatever. So in the GDPR, we of course already have a definition, quite clear. It's any information relating to an identified or identifiable natural person, so-called data subject. And an identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, location data, an online identifier, and so on. And in recital 26, we even then clarified, that was really important for us, that it doesn't mean that you have to know the person by name. You can identify them with their civic identity, so to speak, but it's sufficient if you can single them out. So you can recognize them when you see them again, basically. And that's basically relating to all this online web tracking and stuff. So now the Commission is proposing to change the definition, as you see on the screen, by saying information relating to a natural person is not necessarily personal data for every other person or entity, merely because another entity can identify that natural person. And such information does not become personal for that entity merely because somebody else has means reasonably likely to identify that person. So basically they're saying in the same data processing ecosystem, in the same supply chain, for some entities it's personal data and the whole data protection law applies, and for others it's not personal data and they're completely out and can do with the data for whatever they want. But then somebody further down in the supply chain again would be able to identify that persons, and the whole data protection key would apply. It's a bit crazy. They are arguing this comes from a Court of Justice decision last September, the so-called Single Resolution Board judgment. But that was a very specific case. This was not even about identifiers about persons. It was identifiers about user comments made to the Single Resolution Board, which they handed over to Deloitte for further processing. So the identifiers were not even linked to persons. They were linked to comments. And there have also been other judgments in the past on when is data personal data. The Breyer judgment, you probably have heard of Patrick Breyer, our former pirate member here, where the court decided IP addresses are personal data. Also, if you are not the ISP, the access provider, but just some website. Or the Scania case, where the court said the vehicle identification number is personal data, even if Scania does not know which user has which number, but the registration authorities do so. And again, this is all linked to this notion of singling out. And again, we had a video here, next slide, but we can't play it for you, so we skip it. This is just a small snippet from a movie, a documentary that was done back in the day on the general data protection regulation negotiations, where we had an exchange with the European Data Protection Supervisor, and he also explained what singling out means. The Commission is even proposing more on this front. They're also proposing to give themselves the power by implementing acts to decide when pseudonymized data becomes anonymous data, meaning the data protection regulation, the whole data protection law does not apply. And implementing acts are normally powers for the Commission to apply technical stuff in very specific cases. And they cannot be done for amending core elements of normal legislation. And for implementing acts, the Parliament even doesn't have any veto power. So this is also a bit crazy. But that's what they're proposing. Next slide. We also have another crazy definition proposed, because back then we already said, okay, if you have data already, you can further process it for other purposes, but this is kind of acceptable and not in breach of the purpose limitation principle, because it's fair purposes, so to speak. If you use it just for statistical purposes, scientific research purposes, or historical archiving purposes. And we never fully decided what scientific research mean. I mean, there's a whole Directorate General in the Commission dealing with that. And there's also the research and scientific research associations and bodies who all have an understanding of what scientific research is. But now the Commission is proposing in the Omnibus on the GDPR to suddenly establish a union-wide definition of what scientific research is. And they start with, it means any research which can also support innovation. Yeah. I mean, I'm a former researcher. Before I came to Brussels, I worked at several universities in Germany, the Netherlands, and the US for 10 years, doing research in political science, among others, on the history of data protection. But that was not leading to innovation, you could argue. So I would be out, but anybody who is using data for AI training could argue this is scientific research because it leads to innovation. But they even say it shall contribute to existing scientific knowledge, fair enough, or apply existing knowledge in novel ways. So you just take existing knowledge and apply it somewhere else, and that is considered scientific research. Well, not exactly, I would think. But I mean, you're at the university right now, I understand, so maybe you have thoughts on this. When we discussed it with the commission on technical level in the first round a month ago or so, they already conceded that this might need some fine-tuning. But you see the direction behind this innovation mantra. Next slide. This all is, of course, done with artificial intelligence, quote unquote, in mind. Where the Commission is also now proposing a new Article 88C in the GDPR, where they say using personal data for AI training is in your legitimate interest, which is one of the legal bases for processing personal data under Article 6. But even here, they don't simplify things, because they still say, but if the data subjects, the person's rights and interests override your interest in AI training, then you cannot do it. And you still have to do this balancing test in each specific circumstance. So it's not even simplification. It's just hinting at AI. But even if they would clearly say, no, go back, please. If they would clearly say using personal data for AI training is legal, full stop. Still, there would be problems, because then still my rights as a so-called data subject would still apply, like my right to have my data erased, my right to object, my right to have my data corrected. So, for example, when ChatGPT came out 4 years ago, roughly, I asked it, who is Ralf Bendrath? And the answer was, Ralf Bendrath is a data protection expert, blah, blah, blah. That was okay. But then he is a professor at the Technical University of Darmstadt. I mean, I don't even have a PhD. I never finished. And I've never worked in Darmstadt. So how do I get my data corrected? It's not easy, because there's no database field where they can just change the entry for Ralf Bendrath. It's in the statistical white noise of the weight AI model, you know. Still difficult to have AI with personal data. But then if you ask people what they think about this, it's very clear. Neub, none of your business. The NGO of Max Schrems in Vienna did a survey last year with Meta users. Only 7% of Meta users want Meta to train AI with their personal data. Next slide. So this is basically where we are on AI and data protection. The question, of course, is how to rescue the child in the front. But there's more. They're now saying also my right to have access to my data, to get request and get a copy of my data somebody else is processing, is limited, because I can only use it basically to check data protection compliance. But I cannot use that data for other purposes. That they call that abuse, which is also absurd. I mean, I have this right. It's even in primary law, in the Charter of Fundamental Rights of the EU, and in the treaties. I can request a copy of my data. Okay, I can access my data, full stop, no conditions, no limitations. What I do with the data, it's my data, you know. And this right has been used by, let's say, trade unions when employees requested data about how many overhours they have from their employer. And the purpose, of course, was not to see if the employer is compliant with data protection law. The purpose was to get paid for the overhours. Fair enough. And they now say this would be abuse, because you want to use the data for other purposes, and then the data controller can refuse to give you your data. It's absurd. There's been one case recently at the Court of Justice from a guy from Austria, the so-called Brillenrottler case about a German eyeglasses company, where he subscribed to newsletters of companies systematically to then ask for a copy of his data. And when they didn't give him the data quickly enough, he asked for compensation for immaterial damage. That was kind of his business model. But the guy was all over the place when you Googled him, and it was clear. The court also said he intentionally created the situation where then he would request his data. So this is abuse. Okay, fair enough. But the point is the court was able to decide this on the basis of the current wording of the GDPR. No need to change anything. Okay, then we still have some good elements. I'm not sure if the present announcement of our presentation also contained the words may contain traces of hope. The Commission is also proposing to deal with the cookie banners finally. New Articles 88A and 88B would basically give you a one-click option to get rid of the cookie banners and say, no, don't track me. And they would also introduce, next slide, mandatory, not voluntary, mandatory browser signals, also mandatory for browser manufacturers, to basically automatically tell a website to not track yourself. Which is good. There's still some questions on, can my browser give consent on my behalf, or is it not informed, or things like that. But this is actually going in a good direction. The question is if it will survive, because there's super, super heavy lobbying against it at the moment by big tech, but also by the publishing industry and others, because they of course fear their business model of surveillance capitalism could be undermined with this. There's some small issues that are kind of okay. Easier information obligations for, like, if I become a member of my local sports club and I know that they only use my data for managing my sports club membership, to send me the newsletters and invite me to the summer football tournament or whatever, then I don't need to know if they have a data protection officer or who that is. It's fine if this is very in a limited relationship and so on, totally fine. We can accept that, I guess. They also propose a single reporting point in case of data breaches under different EU laws on data protection, but also on IT security. A harmonized list for data protection impact assessments, when you have to do one and when not. This will now be harmonized on the European level. And this is one of the things Mario Draghi actually said in his report, that part of the problem with the GDPR is the different application and implementation in 27 member states. So if you have things now harmonized on the European level, that's simplification we can support. So far, so good, or so bad on the GDPR. Next is again the AI Act with Thomas.
Yes. So as you've seen, the Omnibus package it doesn't only contain the Data Act, but also a separate proposal for the AI Act, which was under a more expedient procedure because, as you'll see, this was more time critical, and it is already agreed. So we have a result that I think also was voted in Parliament. So this is basically a done deal. So we can look at what has been agreed. The most important thing was really the so-called stop the clock proposal. What this does is it prevented the applicability of certain rules that are aiming to protect us from very high-risk systems of AI, and it would push the deadlines further down. This already has done quite a lot of damage because many member states have used this as a signal to not do their homework, to not appoint the responsible regulators, to not adopt national legislation, to really give effect to the AI Act, although it's a regulation. Some things need to be done nationally for the whole thing to work. Also, you need the budget for people if they have new duties. And all of this was basically shelved, and in several member states is still undecided. So that really is bad because these rules were adopted with a clear purpose to protect society, and particularly the most vulnerable parts of society. We are talking about AI in classrooms, social scoring systems, and the highest forms, the high-riskiest forms of AI. And here we are now faced with a situation where certain risky AI applications that would normally be under clear rules to at least to some damage control, are trying to rush now to market because there's a grandfathering rule. If you're already in the market and after the rules come into effect, you make no further changes, no big changes to the system, then you can basically stay in a regulatory loophole. And this is just inviting bad actors to enter the European market and to do things that otherwise would be prohibited. So that damage sadly is already done. There were some nastier rules that we could prevent around exceptions for the high-risk category. You already had these exceptions in the original AI Act, but they were taken off so that you now could have these exceptions applicable to you even without being in the transparency register. And on this question, we could actually turn the Commission proposal around. There's also one nice thing here, not the ban on notifying apps. I think we can point to Elon Musk here with Grok, who in the middle of the negotiations created such a bad example that everyone could agree that this should really be prohibited. Thanks, Musk, I suppose. But yeah, this is at least the one good thing here. Let's talk about another big law that is part of the simplification agenda, the Digital Networks Act. This is a complete overhaul of Europe's telecommunication code. It was proposed on 26th of January this year, so it's quite new. And it is a drastic shift. Previously, telecom regulation was done nationally because networks are always localized and you have national regulators. And there are big differences actually in bringing internet to people in Sweden where you have fiber everywhere, or Romania where you just throw the cables over the roof, or in Germany where nothing works at all. And you can sometimes be happy that the energy and lights are still on. So the Digital Networks Act tries to change all of that. It tries to harmonize many things, centralize it more in the hands of the European Commission on several fronts. And most importantly for us, it is also a full frontal attack on net neutrality. The Commission proposes to copy-paste the original Open Internet regulation into the DNA, but make some changes that are actually very meaningful, and it would lead to a lot of the case law that we have to be annihilated. Things like the prohibition for zero rating, that you can no longer sell people 10 gigabytes of YouTube and, oh, look, they are 100 times cheaper than 10 gigabytes of normal internet, or sub-internet offers even. Offers where you are paying for individual applications, but not for the whole internet anymore. But the biggest issue looming over this net neutrality debate in this reform is the question of interconnection of network fees. What the Commission is proposing in a soft way, and we now already see in the Parliament that they want to deteriorate this text much further and make it into a hard rule, is to allow telecom providers to get money whenever data wants to enter their network. This means, in effect, this data doesn't inadvertently wander into the network of a telco. It's us internet subscribers, us users that are requesting those videos to be sent, those websites to be loaded onto our browsers. And suddenly that traffic that we are already paying for only reaches us adequately with enough quality if the other side of the connection is also paying. So suddenly a content provider also needs to pay every telco whose customers they want to reach. And that, of course, is the business model of the telephony era. That's the last time where we had these termination monopolies. And the Commission now wants to bring us back to the 90s and to force this telephony era business model on top of the internet. And that is extremely dangerous. We know who the players will be that will benefit from this. We did a survey once of the top 20 zero-rated apps in Europe, and 18 of those were from the US. So there is a lot of industry pushback around this on both sides. The telecom industry has big muscles, and we are in the middle of the debate. One common denominator to what Ralf has said that I want to point out to is that this is a trend that you see in general. Usually the Commission proposes laws, Parliament and Council, so the member states agree on something, and then we have a final legislation. But now we have these carve-outs where the Commission gives itself the power to specify things. It should be technical details, but it's more and more very important decisions that really concern our fundamental rights. On the GDPR, it was the definition of what is pseudonymization and when does data no longer count as personal data. And here in the Digital Networks Act, the Commission wants to decide what is a specialized service. So what is the exception from net neutrality? What is the vertically integrated form of access product that the telco can sell you without even caring about net neutrality? Because it's not applicable. You do not have to treat traffic equally with specialized services. Previously, the law and the regulators decided on this, and now the Commission basically wants to bring this decision under its prerogative. And that, of course, is dangerous because the Commission is a political body and not an independent regulator. We see this very clearly with the Digital Services Act and the inactivity, and I would say inability, of the Commission to do the work of a proper regulator. This is also not theoretical. The network fee debate, the question about interconnection, is in Germany already a problem. That's why the National Consumer Protection Organization, Gesellschaft für Freiheitsrechte in Germany, Access Epicenter Works, and law school professor from Stanford, Barbara Vsevic, are all suing Deutsche Telekom. And we are seeing net neutrality violations and what they're doing when data flows into the network. There's also netzbremse.de where you can read more about this. Let's talk about the strategic implications.
Yeah, because this is, of course, all happening in the context of a broader geopolitical situation, let's say. You might remember already last year in March at the Munich Security Conference, US Vice President J.D. Vance threatened basically to withdraw the NATO security guarantees in case the EU would dare to enforce the Digital Services Act on platforms like X. And last fall, for example, US Trade Secretary Lutnick was in Brussels and offered to lower the tariffs on steel and aluminum if the EU softens its digital rule book.
And now we also have information from Corporate European Observatory that there, of course, was heavy lobbying from big tech in the run-up to the Omnibus agenda, particularly the digital Omnibus agenda. And to give you a sense of the scale, we are talking about, I think it's over 150 millions budget, the official, the white label out in the open budget of big tech when it comes to lobbying in just Brussels alone. And on average, they have one lobby meeting with the Commission per working day. And that gives you also a sense of what we as civil society are up against with our very limited resources. And here, there's also another strategic implication that I want to pause, because the so-called Brussels effect was something that researchers came up with in academic papers describing this proliferation of European high standards in data protection, in consumer protection, in environmental rules, you name it. Those good rules would proliferate simply because Brussels was such a big, Europe was such a big market. And if Brussels sets high standards, most companies would then apply these high standards to their whole portfolio, also to products they sell elsewhere in the world. And other jurisdictions would then also try to be on equal terms with the EU rule book, particularly on data protection. We have also this methodology of equivalency where a country wants to have adequate protection so that data can flow more easily. But this Brussels effect would be completely annihilated if Brussels suddenly reverts itself and changes the rules, particularly on core questions like the definitions of data protection. And so there are 100 plus countries that adopted GDPR-style rules around the world are rightfully questioning whether that was a good idea. And of course, there's criticism.
You already have lawmakers like in the UK, just before Brexit, the UK legislator basically copied the GDPR into the UK law books. So they have a full application still of the GDPR, even they're not under European laws anymore. So based on that, personal data can flow very easily without limits between the UK and the EU because they got this adequacy decision from the Commission based on that. And UK lawmakers are now openly questioning how can we still be adequate with a moving target if the EU now changes its GDPR, But yeah, criticism came from all kinds of sides. Again, a video we cannot show you because the sound is not working remotely, but I can tell you what the guys say. This is from the first plenary debate we had just a week after the Omnibus was presented last November. This is Michael McNamara, Irish Liberal MEP, who basically here says we must avoid a Groucho Marx approach on legislation. These are my principles, but if you don't like them, I have others. These are my laws. If you don't like them, I have others. So yeah, half of the parliament is actually very critical about these omnibuses, the center-left groups in the parliament, but also some of the right-wing people even, but not only them.
We have, for example, the EU watchdog, Ombudswoman Teresa Añejo, who criticized the Omnibus agenda simply because the rule the Commission gave itself around the better regulation principles were not adhered to. There was no impact assessment. There was no meaningful consultation. And on the GDPR, she clearly speaks about maladministration from the side of the Commission. Fun fact, you know how the Commission wants to respond to this criticism? They are now revising the better regulation principles. So they are non-compliant with their own quality standards. So we are simply lowering the quality standards. This gives you food for thought. There's
simplification, hey.
Yeah, the OD regulation. There's also criticism from within the Commission. Commission Executive Vice President Teresa Ribera, she's the number one behind Ursula von der Leyen. And funny enough, also in charge of competition, called the whole spectacle Trumpist and a terrible political spectacle. And you can really see here also a party split between or within the Commission, because most of this agenda is driven by EPP. I always summarize this as it's basically the wish list of the European People's Party. Everything they didn't get in the past decade, they now want to get with the new right-wing majority in the House. Consumer protection organizations are, of course, up in arms about this and many other proposals in this agenda. So are digital rights organizations. 127 signed this particular letter, and many more have come since. And this is, as I said earlier, with the B slide, even going much further than the classical data protection groups, because this so-called simplification agenda, if you are working in the area of law, is really this wrecking ball that you can see right here. So where does this bring us? Where is the hope, Ralf?
Yeah, I mean, it's funny to see that now even companies are figuring out that this whole simplification agenda actually costs money. Because if you have new rules, suddenly, even if they are supposed to be simpler, you still need to adapt your existing business processes and maybe hire some consultants and even lawyers to help you with this and understand the new rules. And some of the rules, like the definition of personal data now, are not even simpler. They're more complicated. And it actually could be more costly to comply. But also the Commission's own red tape hit squad, like Politico calls it here, figured out that simplification isn't actually that simple. You can also see that in the Council. Normally laws are negotiated in Council on technical level by the experts, who often sometimes even fly from their capitals to Brussels for 2 days every 2 weeks or so to negotiate, like the data protection experts, let's say. But the whole simplification agenda is done by the so-called anti-G simplification group. The anti-G are the so-called anti-G are the personal assistants of the EU ambassadors of the member states. So they are generalists. They don't know shit about the details of the definition of personal data, you know. And even they now figure out that it's a bit complicated and you actually might need some expertise in each field to really make sense of these new rules if you want to change them. So what's the timeline? Again, the proposal for the big digital omnibus came on 19th November last year. AI omnibus, as Thomas said, is finished. It was adopted in the June plenary in the European Parliament because there was this deadline on 2nd of August where the high-risk rules would have kicked in, which are now postponed. The data omnibus is only starting in Parliament. Because it was kind of put on hold because the same people more or less are working on the AI omnibus and the data omnibus. So we finished AI first. Now we're slowly starting with the data omnibus. Just yesterday evening, we received the so-called draft report from the 2 co-rapporteurs because it's dealt with in 2 committees. And we have now a deadline for tabling our amendments until 15th of July. So actually this is now a few weeks from now, 2-3 weeks, the opportunity to really reach out to your legislators in Brussels and tell them what they should table in terms of amendments. The position of member states, I put a question mark here when we finished our slides yesterday. It was on the agenda for the EU ambassadors for their meeting today, because Council has already much progressed on this, but it was taken off the agenda because a lot of member states are now also kind of bending in front of super heavy lobbying, in particular on the browser signals and all that, and the cookie banners. So it will not finish in Council under the Cypriot presidency, which ends end of June next week. And now, 1st of July, the Irish will take over the Council presidency for the next half year. And of course, you all know what's the issue with Ireland and big tech.
This is a joke. You could not have written that the Irish will renegotiate the GDPR.
Yeah, but also in the parliament, because it's also a lot of the Omnibus also contains a lot of laws that address non-personal data, like the Data Act, Data Governance Act, Open Data Directive, and so on. It's dealt with in joint committee procedure with the Civil Liberties Committee, my committee, and the Industry Committee. And in the Civil Liberties Committee, we have a rapporteur from the Social Democrats, former cyber ambassador of Estonia, Marina Kaljurand. Very cool, very senior experience, very close to us. Also very outspoken against chat control and things like that. But in the Industry Committee, the chief negotiator, the rapporteur, is Aura Sala, a Finnish conservative, which already is bad enough, but she's a former Meta lobbyist in Brussels. And she's openly saying the EU data protection regulations took a wrong turn 10 years ago when the GDPR was adopted. And we heard that in their first meeting, when they were just trying to sort out the modalities of working together, they were shouting at each other. Yeah, the draft report they presented yesterday was actually, because of that, very small, very thin, because they just couldn't agree on very much, you know. But maybe this is also the approach we should take for omnibuses, because it's different than when you want to adopt a law when there's no rules yet. Then you need to agree on something. But if you want to have an omnibus where there's already a law in place and you cannot agree on changes, then maybe don't change it. You know, that would be my advice. Yeah, on the Digital Networks Act, Thomas, this is your turf.
Yeah, so as I said earlier, the proposal was put forward in late January. It was scheduled for December, but it was postponed. And so now we have it. And we also got the first draft opinions from the two opinion committees, IMCO and LIBE. They are bad, really bad in part, particularly in IMCO. And we have deadline for amendments, I think, till September from the lawmakers. And in these two committees, and then ITRE, the lead committee, comes back in autumn. So we can expect a plenary vote sometime in 2027, I assume. And Council similarly has not made much progress on the file so far. This is a super heavy 300-page legislation that changes several other laws. And therefore, I expect that this will take up this whole term. The rapporteur even said that it might continue beyond this legislative term. So this is a biggie. And again, we have, in 2013, when net neutrality was first discussed and debated in the European Parliament, we had this carrot of roaming that was always used to undermine the fundamental rights, because we really want open internet, but what about cheaper roaming charges? And everybody was kind of weighing these two against each other. And this time we have another carrot. It's spectrum. So they want to use a more centralized approach towards handing out radio spectrum. And that, of course, is again something where the member states have vested interests in the form of several billions for these frequency auctions that are unduly mixed together here in the negotiations. And so we are still in early stages here. It's a normal procedure. It's not as fast as an omnibus. That gives us a little bit more time, but it also means that there's much more intense lobbying on all sides, and civil society needs to really be structured and to approach lawmakers about the importance of having an infrastructure that's neutral, where big tech cannot buy preferential treatment, where every school child has the same access to the whole internet at home, and a teacher, a parent can be assured that there's no difference in how you can use the internet simply because you have bigger or lower pockets. So that's where we are here. And what are activists doing in Brussels? There are actually great examples. One, the Omnibus came out in front of the Parlement, the headquarters of the European Commission, People versus Big Tech, together with Corporate European Observatory, and ADRI did this action where Ursula was called upon to fight for Europe and not for the big tech bros. Greenpeace recently even ended this with making the Parlement the Trump Tower. This was really funny and fitting. And you can see where all of this is going. It is pointing to the real interest behind these reforms and why Europe and should stand firm with what citizens expect, which is being protected from these companies and their AI tools. There's much more substantive work that is happening already, where also more help is always welcome. We have ample amount of policy analysis of reaching out to MEPs. Even the small countries, it's super important that they hear in their own language from their constituency why this is important and what we as society, as academics, as activists, as informed population want to hear from them, want them to do, and raising awareness even by just sharing posts, tweets, policy analysis, blog posts, videos that are funny, or making those videos, or subscribing to newsletters, or donating to NGOs. All of this is super important in this moment. And I think, have I forgotten anything, Ralf, before we come to the post?
No, maybe the idea that if you want to do something about all these omnibuses, but in your local town there is no big digital rights NGO active or something, maybe reach out to the local beekeeping association or the local beekeepers and see if they are aware and if you can help them. You know, they are nice people, I heard.
Yeah, and we live off donations. Our NGO always is happy for more supporting members. This is how we pay the salaries of our staff, and this is what keeps us independent and active and gives us the power to meet this moment. And if we still have time, we would be very, very happy to answer your questions.
I don't hear anything.
Yes, we just unmuted, but not in time for you to hear the great applause that was here. Yes, thank you for the great talk. So now we go to questions. Yes, I will repeat the questions from the audience when they come. There's the first one here.
Okay. If this Omnibus proposal passes in the current bad form, how likely is it that the Court of Justice will just invalidate most of it at least? And if that were to happen, how can it happen sooner? Because I know that my students have been going to the Court of Justice like 3 times, and it always takes a long time.
Yes,
I couldn't really hear very well, sorry.
I think the question was about ECJ, like if the Omnibus passes, couldn't the Court of Justice of the European Union simply annul these unconstitutional changes? And of course it could, but I, as someone who has done this, I can tell you it takes years, and very often the damage is done, and usually you cannot remove it without traces. So the ball post is still moved, even if you win in the court. This is only an ex post help and a patch on the wound. The damage is still done. But Ralf, how do you see this with the GDPR?
Yeah, I mean, on some of the proposed rules, they are probably in the remit of what the legislators can do and cannot do. It's up to the European legislators. But we have different majorities now since 2 years ago, since the last European elections. We have a structural center-right majority. But on some core elements, I would argue, like the definition of personal data, because we already have the fundamental right to the protection of your personal data in the Charter of Fundamental Rights of the Union, which cannot be amended by simple legislation. And the explanatory memorandum of the Charter referred back in the day to the existing 95 directive on data protection and the definition of personal data in there, which is basically copied into the GDPR. We only added the recital on singling out. And therefore, a lot of lawyers say that this definition of personal data basically has constitutional quality already in Europe and cannot easily be amended by the legislator. But it's never been tested at the court. So our hope is to now prevent this in the legislative process. It seems actually that on the definition of personal data, we are already succeeding because in council it is taken out, the changes. And also when we had a first round on political level with the members of parliament who work on this in both committees, basically everybody except the conservatives said we don't want to change it. It's maybe going too far to change such a core element. So on that front, I'm slightly hopeful. But again, there's also other things like this crazy definition of scientific research and commission empowering itself to do implementing acts and all that shit, and the abuse of data access requests where we need a political fight. I'm not sure if we could challenge that in court, actually.
About how long it always takes to go to the Court of Justice. Is it kind of a structural issue with how the EU works, that it always takes 3 years or something, or even more, to get a decision, for example, in the Schrems-Law Order 2 case?
Again, I have issues to understand the audio. Maybe the people need to get closer to the microphone or so. But did you understand, Thomas?
No, not completely. Could you repeat, please?
Yes, I can repeat the question. So the question was, if I summarize it, is why normally it takes so long for...
It's a structural issue within the European Union, basically.
If it's a structural issue within the European Union, that it takes so long to adopt, yes. They capture everything?
Yeah, I mean, so of course, Europe is much better than the US in making laws, also because it took a completely opposite approach. Every branch of government in the US can start a law, but it's very hard to finish one. In Europe, it's super hard to start it, but then it's almost inevitable that something with that title will be finished. Yes, it takes longer. National lawmaking usually half a year, EU usually 3 to 5 years, roughly. And so therefore, we have much more players that are involved. This is not a homogeneous body. There are still a lot of diversity within council and parliament that needs to be ironed out. And then we have these crazy things called trilogue that are super undemocratic, but this is how it's done. So there are definitely structural issues that deteriorate the quality of lawmaking, particularly the ones where we have less transparency. I would argue against. But in general, I'm still, as someone who works on both fronts, would say that on European laws, we have better quality and people are actually thinking it through. Whereas in national legislation, I can point you to so many dirtily drafted things that are just the brainchild of a few people that never really took outside advice into consideration even. So I'm not sure what it's actually structurally bad in terms of quality. It could be expedited and faster. But then again, if that would make the quality of the laws worse, I wouldn't like it. Let's be slow and good.
Maybe also to point out that the European Parliament is kind of a unique body. It's not working like normal national parliaments, because in national parliaments, you normally have a clear division between the governing coalition and the opposition. And the coalition normally supports laws that come out of their government, out of the ministries, and then they are maybe slightly amended in the parliamentary procedure, but normally you follow your ministers, and then it gets adopted. Here in Europe, it's different. You have the commission, but the commission is kind of, once elected, it's like the other institution. It's not really, it's the other institution. And when the commission makes a proposal, it really, in each case, we can see where the majorities lie, even within a legislative proposal for each topic, let's say. Sometimes we have center-left majorities. I mean, structurally we don't have them anymore after the last election. But when we have reasonable people within EPP working on a file, and we have good arguments also, then it's often easy to convince also conservatives that they should go this or that way. But on other fronts, if the conservatives want to do something really against us and the socialists and so on, they now can have a structural majority with the far right and the fascists. But even there, sometimes the fascists, like the Patriots for Europe, are closer to us than to EPP, in particular in issues around data protection and privacy, thanks to the chat control fight, because suddenly they are where the people care about their privacy. And as good populists, then they listen, So it's really not clear at the beginning of a legislative process how the outcome will be. It's sometimes a bit difficult for people out there, but I think it's more reflecting the actual will of elected people here.
Yes, thank you very much. And now I think because we're running a bit out of time for the lunch, I think we will cut it here. So let's thank our speakers and the speakers for the entire session.